In a previous look at federalism, I compared the three systems of government, a unitary system, confederate system, and then a federal system, so that you get a better sense of what state sovereignty means and the give and take between the national government and the state governments in the United States of America. Now, what I'm going to do in this presentation is I'm going to take you to parts of the specific parts of the U.S. Constitution, because our very unique system of federalism really is rooted in what the Constitution has to say. So you may recall that one of the weaknesses of the Articles of Confederation was that was recognized as a weakness in the strength of the national government. So one of the most important things that early Americans, when they decided to move from the Articles of Confederation into something new, which we're studying now, called the Constitution, it was recognized that they needed to do something to make that national government stronger. So let's take a look and see some of the provisions in the U.S. Constitution regarding how our system of federal government works. Now, federalism is a system of shared powers, and as I explained in the previous presentation, there are some things that the national government has the authority to do, and there are some things that only the state governments have the authority to do. But then you also have an overlap, quite a bit of overlap, in fact. And in fact, over time, remember our Constitution was ratified in 1789. Over time, here in 2023, the state has voluntarily given up some of its autonomy in many ways. And as you work your way through the module on federalism, you'll learn about something called federal grants. The national government will take some of its tax revenue from the income tax and give it back to the states. And when they give it back to the states, oftentimes there are strings attached, which may give the national government some control over what goes on in education, or it may give the national government some control over business, depending on how that grant money is used and what the strings are that are attached. So again, this is nothing that this is a way that the national government, both Democrat and Republican, by the way, parties, when they're controlling the national government, this is one of the ways that they've learned they can get around the restrictions that are placed on the national government in regulating certain topics. They've learned that if you offer the states money, then the states will willingly take that money. And oftentimes when the national government offers money, there are strings attached. So let's go ahead and move along then. So remember that a Constitution is really a document that sets out parameters of operation. Our U.S. Constitution sets out the limits of power of the national government and sets out the limits of power for the state governments. In essence, a Constitution does two things. It creates government, and then it provides operating instructions for government. Now, you can imagine that the folks back in 1787 at the Constitutional Convention, they understood that there was going to be a lot of struggle. There was then, and there certainly is now, over who gets to control what. The states are very, very zealous about controlling things within their own borders, but at the same time you have officials in the national government who think that this is a question that should be settled, or a subject that should be settled by the national government with little input from the states. But this is a continuing struggle. But to make that struggle a little bit more palatable, the Constitution does lay out some parameters of operations. In other words, there are basic understandings or basic rules that apply. The state government gets to do this, or the national government gets to do this. So what I'm going to be doing in this presentation is taking you to parts of the U.S. Constitution that touch on the relationship between the national government and the state governments regarding authority and power. Another way to look at this is as I work my way through this, I'm going to show you key provisions of key provisions in the U.S. Constitution that affect state sovereignty. State sovereignty is a key idea in the topic of federalism. So the U.S. Constitution then, in many ways, and I want to show you what those ways are here in just a moment, it lets us know whether the Texas government or state government in general, or whether the United States government, the national government, has authority over a particular subject. So we're always going to go there first. We're going to go to the Constitution because it is the starting place. And as I've already said, state sovereignty is the key concept for this topic. So the provisions I'm going to show you in this presentation, I hope that you take some time to look at them yourselves. In your course site, I've linked you multiple times, and we'll continue to do so, to the U.S. Constitution. Most textbooks have a copy, most textbooks in federal government, that is, will have a copy of the Constitution in the back of it somewhere. Texas government textbooks don't always have that, but if this is being used in a Texas government class, if you're watching this in a Texas government course as opposed to federal government, because I use this for both, you may not find a copy of the U.S. Constitution in the back of your textbook. If not, you can certainly look around in your course site, and you're going to be able to find it there. It's easy to find a copy online these days of the U.S. Constitution. So my suggestion is you pause from time to time this presentation and look at the Constitution itself. So one of the first places I want to take you is to Article 1 of the U.S. Constitution. Article 1 creates the legislative branch, and we'll take a closer look at the legislative branch in federal government at another time. One of the most important parts of Article 1, which is about lawmaking, making law, is Article 1, Section 8. Article 1, Section 8 is referred to as the enumerated powers of Congress. It's the enumerated powers, a list of powers. It's a list of powers that Congress has. And if you take a closer look at that, it's a list of subjects that the national government, the government in Washington, D.C., has the authority to regulate. They have the authority to regulate. For instance, you'll see that the national government has the authority to create post offices and to create postal roads. You'll see that the national government has the authority to coin money. I mean, if you think about it, when you look at a dollar bill or if you look at a coin, you're not going to find the state of Texas on that. You're going to see the United States of America. The U.S. Constitution gives that authority to coin money specifically to the national government. If you think about that, it makes sense. That way we have consistency regarding currency across the country. No matter what state you're in, you can use the same currency. Thank goodness. So Article 1, Section 8, it's a list of powers that Congress can regulate, a list of subjects that Congress can regulate. Article 1, Section 10, and again, I hope that you look at this more specifically on your own. Article 1, Section 10, it lists the subjects that states have no authority over. So this Article 1, Section 10, it's really just 3 paragraphs. And in the first paragraph, it's very specific. These are subjects that the states, these are things that the states cannot do. It's just a very, very short list. They just simply can't do these things. In fact, I thought I'd go ahead and take you to Article 1, Section 10 so you can see exactly what I'm saying. See, if you look at this section, this is Article 1, Section 10 of the U.S. Constitution. You notice the language here. It says, no state shall do this, and no state shall do this, and no state shall do this. And then the first one, there's no exception. There are certain things that states can't do. For instance, the state of Texas cannot enter into a treaty with Mexico. That is something that they simply cannot do. That is reserved to the national government only. But if you look at the second paragraph and the third paragraph, there are exceptions. So this paragraph here contains things that the state governments can't do unless they have the authority from Congress to do it, right? So no state shall without the consent of Congress. And the same thing down here, no state shall without the consent of Congress. So this language, without the consent of Congress, you don't see that in the first paragraph. So there are certain things that states can't do unless they have permission from Congress to do that. So let me give you an example of something that Congress has given permission to the state of Texas to do. You all know that we have troops here in the state of Texas. We have the Army National Guard, we have the Air National Guard, and in fact we have something called the Texas State Guard. So the Texas Army National Guard, the Texas Air National Guard, and the Texas State Guard. These are all militaries related specifically to the state of Texas. But Congress, a long time ago, and particularly, they looked at this very carefully, Congress did, between the two world wars, World War I and World War II, when national security was a real big question. And we got involved in the First World War in the teens, and then in the 30s and 40s, Europe finds itself in the Second World War. We eventually joined them. Well, during this period of time, Congress looked at this language and created multiple laws and multiple acts or statutes allowing each state to have an Air National Guard or eventually Air National Guard and then an Army National Guard. So Texas having troops, the only reason we can do that is because Congress has given us the authority to do that. Okay, so that's Article 1, Section 10. And again, I do encourage you to take a closer look at Article 1, Section 8. I know that your textbook refers to that. But let's move along here. Here's another part of the Constitution that deals with the sovereignty of a state, that is, authority of a state. Article 2 of the U.S. Constitution, of course, addresses the executive branch. But specifically, if you were to go to Article 2, Section 2, what you'd find is that the president has authority over the militias of states. So I mentioned a moment ago, we have this thing called the National Guard. In the old days, the National Guard used to be called the militia. Now we call it the National Guard. That designation was given by Congress in those laws that I referred to earlier. So back in the old days, and what was referred to as a militia, now we call that the National Guard. So Texas militia then really takes the form of the National Guard. So the Constitution says that the president from time to time can take charge of a state's National Guard. And later on in the semester, I really want to show you some real examples of how that happens. You all know that multiple times actually involved when the U.S. government and the U.S. military was involved in the Middle East. There were some times when the president, then sitting, I think of George W. Bush, the second president, and actually, if I'm not mistaken, the first president as well, first President Bush, they actually took control of the state's National Guard, the Texas State National Guard, and used those Texans over in the Middle East to support the Army and the Air Force and the Marine and the Navy. So if the president has not taken charge of a state's National Guard, understand that it's the state's governor, though. If you think about Texas, Governor Abbott actually is the commander-in-chief of each one of those guards, Texas Air National Guard and Texas Army National Guard. The Governor Abbott is the commanding officer, or rather the chief executive over that, the commander-in-chief, unless the president takes that authority away temporarily in order to use that National Guard for national purposes. You may recall that when Harvey was hitting the Houston area and when Harvey hit the Texas Gulf Coast, Governor Abbott took charge or ordered the Texas Army National Guard to help out flood victims in Houston and to help out flood victims along the Gulf Coast, Corpus Christi area, and other counties. And in fact, Governor Abbott has taken the Army National Guard, the Texas Army National Guard, and stationed some of those troops along the border to help with border security. All right, so a president has the authority to take charge of a state's militia, which we now call the National Guard, from time to time. Let's move along. Article 3, Section 2 Article 3 deals with the judicial branch, and there are some grants of power to the national government's judicial branch when it affects, as it relates to lawsuits within a state. So the question is jurisdiction. So what I'm going to show you here in this slide here is what the U.S. Constitution says about the authority of the federal courts. So in the state of Texas, we've got over 1,000 courts. Okay, we've got 1,000 trial courts roughly. 4 of those trial courts belong to the national government. The other remaining courts are all related to the state. In Texas government, you look more closely at the court system, but there are really only 4 trial courts in the state of Texas within our boundaries that represent the national government. We have something called districts. Texas is divided up into 4 judicial districts for the national government's purpose: northern, southern, eastern, and western judicial districts. I will look probably more closely at that when we look at the courthouses. I'll remind you of that if you're taking this for Texas government. We will certainly look more closely at that in federal government if you're taking this for a federal government class. But what you've got here is a portion of the U.S. Constitution which grants jurisdiction to the national government's courts inside of a state. So jurisdiction is a word that means power, and more specifically, jurisdiction is a reference to the ability of a court to render a binding decision in a case. So I know you've heard of that term jurisdiction before. In the court system, it has a specific meaning. It is the authority that a court has to render a binding decision in a case. Now, Article 3, Section 2, Article 3 creates the judicial branch of the national government, and it creates the U.S. Supreme Court. What you're looking at behind you is the U.S. Supreme Court. Now, the question is, of those 4 courts, the practical question is, of those 4 courts in Texas, those 4 U.S. district courts that represent the national government, what kind of cases can they hear? Well, let me start off with this general proposition, and that is most of these courts in the state of Texas, as I've already said, are state courts. Texas will generally clean its own laundry. It's going to clean up its own dirty laundry. Most disputes between people and between businesses are not going to be resolved by those 4 courts that represent the national government. If you go down to downtown Houston on a Monday or Tuesday, you're going to see those courts downtown are packed, and they will continually be packed. But they're packed with issues that are specific to Texas and have no bearing whatsoever on national law, congressional law. So what you're looking at here is a summary then of the types of cases that the national government's court system has jurisdiction over. So if it's a case related to the U.S. Constitution, those 4 district courts in Texas can exercise jurisdiction over it. If it's a case about a law produced by Congress, that is, that's produced by the U.S. House, U.S. Senate, signed by the President into law. If it's a federal law or a law produced by Congress, those 4 courts have jurisdiction over it. If it's a dispute between people from different states, the federal courts can exercise jurisdiction. I will say this, that usually there's a dollar amount. The last time I checked, it was over $150,000. You couldn't use the federal court system unless the dollar amount threshold that you were suing for had reached a certain amount of money. But the general idea here is that if you want to use the federal court system to sue somebody from another state, then you can do that. And I think the idea here is fairness, right? You want to make sure that you don't have a biased judge who's going to rule in favor of their own citizen from their own state. So we get the federal courts involved. And maritime cases are cases that are types of lawsuits that relate to what goes on at sea. So you all know that in Galveston, for instance, we have those Carnival cruise ships leave the island all the time. But what if one of those Carnival cruise ships leaves Galveston and collides with one of those big tankers coming into Galveston Bay to drop their load in at one of the refineries there in Houston? Well, that's going to be a maritime case. And maritime cases, collisions, for instance, over out in the ocean, out in the Gulf, or maybe even you've got some sort of incident on some sort of an oil platform, arguably a type of maritime case. Okay, let's move on a little bit further. Now I'm going to look at some miscellaneous provisions. So Article 1, 2, and 3 of the U.S. Constitution, those deal with the specific three branches. Article 1 deals with the legislative branch, Congress. Article 2 deals with the executive branch, the presidency. Article 3 deals with the judicial branch, the U.S. Supreme Court, and the courts that fall below the Supreme Court. But Article 4 is a miscellaneous provision. Miscellaneous provision really is about, Article 4 really is about the relationship between the states. And so let me put this out here. Article 4, Section 1, it says in summary that each state must give full faith and credit to the acts and judiciary decisions of each of the other states. Now, when you look at this, what you need to think about really for the most part is court cases. That's predominantly what we're looking at here. And in other words, if we have a lawsuit being determined by a court in Texas, and you have a court decree, whoever loses that case in Texas can't take that same lawsuit and trial all over again in Louisiana. Okay, that's what this provision here is supposed to avoid. Let me give you a couple other examples, because it's not just court cases, but predominantly what we're looking at here is court cases, that each state must give full faith and credit to the action judicial decisions of each of the other states. It's not every law, but it's certain ones. So let's take marriage just as an example. Let's say that a couple get married in New York State, and then they move down to Houston because they both have new jobs. So there's a marriage license in New York State, and when they move to Texas, And the question is, does Texas have to recognize them to be married? And the answer to that is yes. Okay, so the state of Texas is going to recognize that New York marriage as valid. It's going to give full faith and credit to that marriage, that New York marriage. But let me give you another scenario. What if this couple decides to get a divorce in Houston, Texas? So they've lived here a few years and they decide to get a divorce. She decides to stay in Houston. He decides to go back to New York. Okay, so they get a divorce in Houston, in one of the district courts, one of the state district courts in downtown Houston. There's a divorce decree been granted by a state district court. So the question is, when that man returns to New York, does the state of New York have to give full faith and credit to that Texas court divorce decree? And the answer to that is yes. So this is what full faith and credit means. It simply means that there are certain laws, certain judicial acts, and again, what we're looking at here primarily is are court actions, although that's not always the case. Court actions. Okay. States must give full faith and credit to that. Another thing regarding the states is this an interesting one? Because this is a guarantee to the states that only Republican forms of government can exist within the nation. And when you look at that term Republican, don't think about political party. This language was put in the Constitution long before the Republican Party was born. Okay, a Republican form of government is simply a representative form of democracy. It's a form of democracy where we the people don't make the law, but rather we elect people to make the law. Our elected representatives make the law. Our elected representatives set the policy. That's a Republican form of government. And as strange as it may seem to us today, because remember, you're looking at language inserted in 1787, then fully ratified in 1789. As strange as it may seem today, what this does, it prevents states from having some other form of government at the state level, like a monarchy. Again, I may sound strange today in 2023, but that wasn't so strange back in 1787, okay? It wasn't so strange back in 1770s to think that a state may actually try to form some sort of a monarchy or something other than a Republican form of government. And all this section really does is guarantee to the states that, hey, if you come into the Union, you become a member of the United States, you become one of those United States, the national government will guarantee to the people that you will always have an elected form of government. You will always have an indirect form of democracy. Okay, let's move along to another miscellaneous provision. This is Article 6, and this is really the language that you may have heard. This is Supremacy Clause. Okay, this is what makes the circle in the middle of those diagrams that I showed you all when we were comparing systems. And I referred to this provision of the Constitution when I made that presentation as well. And if you're looking at this and you're not viewing a presentation, I'm sure that I addressed that question or that subject when we looked at this during the live class time. But Article 4, the second paragraph of Article 4 of the U.S. Constitution has this interesting language, and it really lists three categories of laws. The laws produced by Congress, the U.S. Constitution, and treaties. Those are really three categories of law. U.S. Constitution is a super law. Laws produced by Congress, those are federal laws. Those are statutory laws produced by U.S. senators and U.S. representatives. And then treaties. So treaties are negotiated by the president, and then they're ratified by the U.S. Senate. And once they're ratified, they become a type of law. They have the full force and effect of law. Well, those three categories are the supreme law of the land, according to Article 6, Paragraph 2. In other words, because of the supreme law of the land, states cannot have laws, or they can't have laws in effect that actually go contrary to the U.S. Constitution or laws produced by Congress or treaties. Now, there are some qualifications for this, but that's the general proposition. Those three categories of law are going to trump anything that a state produces. And there have been multiple instances where states have tried to wiggle their way around this, only to see their efforts declared unconstitutional by the U.S. Supreme Court. Perhaps we'll take a closer look at some of those when we get further along in the semester. Now, I want to show you something else. Now, what we just looked at are parts of the main Constitution. Now, I want to take you to the last part of the Bill of Rights. So the Bill of Rights, Amendments 1 through 10. The Bill of Rights were added to the Constitution in 1791. The Constitution was ratified in 1789. 2 years later, we insert the Bill of Rights. Amendment 10 is referred to as the Reserved Powers Amendment, and you can see, really, it's very short. In the upper right-hand side of this presentation, you can see the language here. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Another way to look at this, and this is rather loosely, but I think it's generally true, go back and think about Article 1, Section 8. Remember the enumerated powers? That's a list of things Congress can make a law about. If you don't see that power, excuse me, if you don't see that power granted to the national government, then by default, that is the domain of the state governments. You may recall Article 1, Section 10, prohibitions to the states. There are certain things that states can't do, such as coin money. Okay? But unless there's a specific prohibition to the states, and unless that subject has been assigned to the national government, Article 1, Section 8, then it's going to be reserved to the states. And this is a source, this is a place that the states will go frequently and continuously when they think the national government has passed a law that it has no authority to pass. Okay? There have been multiple instances where the national government has passed a law only for that law to be challenged by one of the states, and then the U.S. Supreme Court, whose job it is to apply the Constitution to a specific case. The U.S. Supreme Court doesn't always side with the national government. Frequently, they side with the states. Okay, and so it's the U.S. Supreme Court's job to hear cases like that and just make a decision whether or not this was something that the state should have regulated or the national government should have regulated. So there are certain things, if they're not granted specifically to the national government, it falls into the lap of the state governments. For instance, family law, that's a good example, falls into the lap of the state governments. So provides that power is not specifically given to Congress and not prohibited by the states, is reserved to the states. This is referred to as the States' Rights Amendment. Gives states a lot of local autonomy. Now, the last thing I want to look at, and we're going to look at this more closely when we take a look at in federal government at civil rights. But Article 14, or rather Amendment 14, which was added to the Constitution after the Civil War, it's a very, very important amendment. And I'll probably touch on this. Well, I won't be able to for all my classes because I won't in live classes. Or rather, I will in live classes, but not on my online classes. But what it does, one of the most important things it does, is it defines who a U.S. citizen is. And keep this in mind, the target here is the former slave population. The 14th Amendment was added to the U.S. Constitution in 1868. That's 3 years after the end of the Civil War, and there's some history here. So bear with me as I try to explain this. Amendment 13, the one before this, ended slavery. That was ratified. The prohibition in slavery, the 13th Amendment, was added to the U.S. Constitution in December of 1865. 3 years later, this is added to the Constitution, and make no mistake about it, this is about the former slave population. Now, we here in 2023, we use the 14th Amendment in many, many ways, but historically, the primary reason it's added to the Constitution is the way that the southern states and even some of the northern states were treating the former slave population. And so what this does is it attempts to rectify some poor treatment of the former slave population and their children. And so this is inserted into the U.S. Constitution. And remember what we've already learned. Once this is inserted into the U.S. Constitution, it becomes the supreme law of the land, no matter what a state may do. So one of the most important things in that the 14th Amendment does, it defines who a U.S. citizen is, okay? And it says simply, if you're born here, you're a U.S. citizen. If you're born in the United States, you are a U.S. citizen. Or if you go through the process of naturalization like my dad did, you're a U.S. citizen. So it points a finger at the former slave population in essence and said, look, these people are U.S. citizens, and they're also citizens of the state where they reside. Okay, so that's a major, major statement. When I was living in Canada, we had a choice to remain in Canada, but if we were to remain in Canada any longer than what we were allowed to do under law, we would have had to have begun the process of becoming a Canadian citizen. Now, at that time and place, if I, as an American citizen transitioning over to Canada, had I transitioned to become a Canadian citizen, I would have lost my U.S. citizenship. My wife and I were not willing to do that, okay? There are certain rights and privileges that come with being a U.S. citizen. So what Amendment 14 does, it looks at the former slave population and their children and says, look, these people are U.S. citizens. Now, once it does that, it begins to point a finger at the states and essentially says that you have to be very, very careful how you treat these U.S. citizens. Don't look at them as former slaves, look at them as U.S. citizens, okay? And this is the supreme law of the land. States cannot take away the fundamental rights of U.S. citizens, okay? It provides that states must provide equal protection of the law to U.S. citizens. Provides that states must provide due process of law to U.S. citizens. And again, you have to put yourself in the context in the Reconstruction era, in the era of the KKK, all right, when the KKK is really born, where where the states are trying to keep the status quo. The states, the former slave population is no longer. They are now freed, and now this defines them as being U.S. citizens. Well, I've gone longer than what I wanted to do, but I did feel like this was necessary. So I do encourage you to take a look at the Constitution itself and go back and review this.